Good morning, everybody, and welcome back to the Law and Crime Network. I'm your host, Jesse Weber, and thanks for joining us today. So I want to give you an update, a preview about what we are going to handle today. At around, we expect around 10 a.m. Eastern Standard Time, we expect opening arguments in a new case out of Iowa. This is the case of Larry Whaley. He's 60 years old, and he's been charged with first-degree murder in the death of 19-year-old Samantha Teeter by shooting her through the door of his apartment. Whaley has actually written letters to the judge in this case, Judge Christopher C. Foy, claiming he wouldn't receive a fair trial. Evidence is being withheld. His attorneys are lying to him. There's been witness tampering. His cell phone and car have been stolen, and his rights have been violated. Actually, I just want to correct myself. He has now been charged with second-degree murder. It has been changed. He's been charged with second-degree murder. Now, he seems to be claiming self-defense. He says that the killing was not intentional. In fact, after the shooting, officers said Whaley was talking to himself and was saying they were trying to break in. Now, there was a question about whether or not he was even competent to stand trial. Well, it was determined that he was competent to stand trial, and he faces a trial today. Again, we do expect opening arguments, and as soon as we have a live feed in that courtroom, we'll make sure to go to it. We also want to talk a little bit about Jeffrey Willis. There was a hearing yesterday. There was a sentencing hearing yesterday regarding this guy, and I have to tell you, it was full of dramatics. At one point, Mr. Willis blew a kiss. I'm not even kidding you, blew a kiss to the gallery of the victims' families. And you heard, we'll show you that in a bit. And I also want to delve into the psychology of this man, of Jeffrey Willis, because as you remember, he has been, he was found guilty of first-degree murder of Rebecca Bletch. And also he will be facing trials related to the disappearance of Jessica Haringa and also the potential abduction of a teenager. This guy has quite the history, and it's definitely something we're going to follow today. And then finally, later on today, there's another case that we hopefully might be able to cover. It's about a pretrial conference out of Arizona related to a gentleman named Thomas Robinson. Now, he is a municipal court judge. He was arrested on suspicion of domestic violence and tampering with evidence. Robinson told police detectives that he stabbed his wife 10 times at their home, but he what happened was he originally told police, and his wife told police, that an intruder had come in and done this. They originally blamed it on someone else. Well, it didn't last long because his wife said that he was in fact the person who stabbed her. But it doesn't end there. This is quite the story. Even though his wife did implicate him as the attacker, she said she forgives him and that he wasn't acting like that. This was something out of the ordinary. She wants him home. She wants the charges dropped against her husband. It's a really, really bizarre case. We'll talk more about it today. We do expect a pretrial conference later on today, and if we do have a live feed, we will make sure to go to it. And then finally today, we might talk a little bit about Curtis Reeves. You might have remembered this case. This gentleman who was in a movie theater and killed a gentleman named Chad Olson in what he claims was self-defense. And we have that video. You've seen that video of where he shoots him, believing that they got into some sort of confrontation. Mr. Olson had thrown popcorn in Mr. Reeves' face, and Mr. Reeves took out a gun and shot this man dead at point-blank range. Now the question became, is this self-defense? Well, originally a judge ruled that it was not self-defense, but he has appealed this decision to a higher court, and the higher court has actually found that there's merit in this stand your ground case. And remember, if they do find him that this was self-defense, he gets off the hook. If they don't find it was self-defense, then it goes to trial. And we will talk a little bit more about that. We showed a hearing yesterday about it, but it's definitely something for discussion. But right now, one of the great things that we have here on the Law and Crime Network is we get a whole collection of guests talking about different aspects of the case. But one of the really interesting things is we have some really colorful defendants who it's a little bit tough to understand what's going through their mind and what's the psychology of their actions. And it's really helpful for us and the viewers to understand that. So I'm very pleased to announce that today joining us is forensic clinical psychologist, Dr. John Huber. Dr. Huber, thank you for coming back on the program today.
Well, thank you for having me on, Jesse. I appreciate it.
I want to start with this Larry Whaley guy out of Iowa, okay? A lot to dissect here, okay? I want to just understand if I get this correctly. In your experience, somebody, and maybe you've seen it yourself, somebody who has taken the initiative and starts contacting the court, specifically the judge, claiming all of these things, that he didn't receive a fair trial, that his attorneys are lying to him, that there's witness tampering. Is this a sign of paranoia, or is this something that he might be really telling the truth here? I know that might be a loaded question, but I am curious.
Well, again, usually when I'm in court and these things are happening, I have access to the client and I can go in and do my own investigation. So again, this is kind of tongue-in-cheek. I have not investigated it and met with Mr. Whaley and all that kind of stuff. I just want everybody to know that. But it could be both ways. Unfortunately, in my experience, the majority of the time it is that paranoia. And, it sounds like he's grasping at straws. He's looking at anything. And, he shot through the door, so he didn't really know what was on the other side of the door anyhow. At first degree, when they initially said it was first-degree murder, I think he just panicked and started responding any way he could. Now it's the second degree. We'll see how that plays out.
Yeah, I mean, but in your estimation, or when you see people, defendants, who are acting in a way that I would know their attorneys who eventually represent them wouldn't approve of, where they're, speaking out on their own behalf, what do you make of defendants that do that? And I know every case is kind of different, but trying to understand from his perspective.
Well, a lot of times, it boils down to the defendant's personality. They just can't keep their mouth shut, and they have to have their story told, assuming that, he is mentally stable. I know he's been found competent to stand court, or stand trial, but I do know that he could be floridly psychotic and still meet the criteria for competency. I've evaluated people that way myself. And so there could be some mental health issues going on in this situation, or it could be, again, just that personality type that he has to get out there and tell everybody what's going on.
The idea that he is competent to stand trial, if you could explain to our viewers, what does that mean? What does that really mean from that perspective?
Exactly. Competent to stand trial, it boils down to a few things. First of all, they understand the charges against them, and they understand the potential range of sentencing they could have, from being found not guilty and walking out of the courtroom to whatever the extent of the charges are, in this case, second-degree charges for murder. That's the first thing. The second thing is they have to be able to help in the defense of their case with their attorney. So that means there has to be a certain level of communication that's there, and a certain level of grounding in reality. But again, that reality can be the defendant's reality and not what everybody else sees. You have a question?
Oh, no, I think it's fascinating, actually. I love having you on the program, because we can try to understand it from one perspective, but I like hearing really from a professional here to try to understand it.
Exactly. And again, they can be floridly psychotic and still meet those first two criteria. The third criteria they can still meet as well, and that is that they know and understand how to behave in a courtroom. And they know, for example, when the judge walks in, everybody rises. Those basic, simple things. And there's actually evaluations where we sit down and ask them, what does the bailiff do? What is the defense attorney? What is the prosecuting attorney? And if the client can go through and explain all of those, then that's one more step that says they are competent. Now, all the time they're answering these questions, they could be talking to angels or demons and things that you and I can't see, but as long as they're answering my questions appropriately, they meet the requirements. And that bothers some people. In some cases, judges have ordered that clients take medication and things like that to do that, but that is not the usual case. If the client wants to not take medication unless their behavior is so bad, they oftentimes have that right to not take medication.
Right, as you said, because if they believe in angels and demons circling around, that becomes a question of the insanity defense and really what becomes the issue there. But the idea of that, knowing that they're in a courtroom, what's happening, that's really, really important. I know that, again, we don't know so much about the case. We really are waiting to hear the opening arguments and what to expect. But the idea that he might have been talking to himself after this crime that they were trying to break in, What is that?
Different things. It could be some kind of drugs. I mean, if he was taking, LSD or, psilocybin mushrooms, maybe even, lots of cocaine or meth and stuff like that. All of those can cause that kind of behavior. And I think it's an interesting thing. You mentioned the insanity defense. Well, to plead insanity, you have to be competent to stand trial. So
That's
it sounds like it contradicts itself, and it's kind of funny, but the reality of it is you have to be competent to be able to make a plea. So if you're not competent, that has to do with what your state of mind is at the time of trial, not at the time of the alleged offense.
See, that's so interesting because we see people try to take go by the insanity defense, claiming that they didn't know that their actions were against the law or wrong. So eventually, if they are arrested and the argument becomes they get arrested, they're appointed counsel, then they realize, okay, I guess what I did was against the law, and now they understand the framework of what is going on, what happened. But that's what makes this so interesting, and that is why I think the insanity defense doesn't work. I mean, it's extremely rare. It's extremely rare when it's put forward, and it's extremely rare that it actually works. I wonder if that might have been a conversation here. Again, we don't know all the details of it, but the idea that he's saying that this was self-defense and the killing was not intentional, I would imagine for these kind of cases, this guy might take the stand and try to understand what's going on in his mind at the time.
Well, reading all the reports that I've had available to me and stuff, it sounds like he was in his apartment and doing whatever, drugs or sitting there in his psychosis, whatever. We don't know his state actually at that point at this time, but he thought he heard people trying to get into his home, and then he just fired point blank through that door without knowing who was on the other side. And that's where I think he's arguing there was no intention. He wasn't trying to kill his neighbor. He was trying to defend himself from somebody he perceived to be there. That's just what I get from reading all the letters he's written and all that type of stuff. So how accurate that is, we weren't there. That's the problem. That's what the jury has to decide and the judge has to decide.
Yeah, and it's not an easy decision. I mean, we know that the jury selected was 5 men, 9 women.
Right.
It's interesting. I know we've talked about this before, but since I have you on the program and I haven't had you here in a while, if you can explain when a jury starts. I mean, a jury is going to be starting today, hearing this case. The decision to hold another man's life in their hands about whether he'll be found guilty or innocent. I'm sure you've spoken about this. I'm sure you've thought about this before. What are your thoughts on that in terms of that's not an easy decision for any human being to make, to be put in that position?
Exactly. It's a scary thought that, we're relying on somebody else to determine whether you live or die. I mean, but it goes back to, the thumbs up or thumbs down back in, the Roman times, like, should we kill this person or not? But now we have a jury and they're responsible. And usually what happens is the judge gives them parameters and explains to them rules that they should take into consideration. I think they should follow them. However, juries can do what they want to do. That's the way it is. So they may take into consideration other things that the judge told them not to and things like that. But it's a very heavy thing. And one of the questions that we often ask in our surveys is, could you sentence somebody to the death penalty if that's available? And it's really interesting because some people think that should exclude them, and so other people say, no, that should be included. They should be included in the jury pool if they answer that way, an affirmative. So it's all philosophical, and some attorneys hire people like me to come in and create the questions, and based on research and data. The difference between an attorney doing it and a psychologist doing it, usually statistically, there's only a 2 or 3 percentage point difference in the outcome. So there's no statistically significant advantage to using an expert in jury selection at that point.
Well, the jury didn't have a problem in the case of Jeffrey Willis, which we're about to talk about.
Right.
Yeah, they found him guilty of first-degree murder of Rebecca Bletch. Now, I want to, Dr. Huber, I'm so happy you're here because I really want to try to get into the psyche of this guy. Yesterday, during his sentencing hearing, he opted to not be present when the victim family members made their statements, these victim impact statements. But that's not it. That's not it. To show you the arrogance, watch what he did when he left the courtroom. Let's play our clip right now.
All right.
Terrible, 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 terrible. Now, for our viewers who didn't follow this case so much or don't know what's happening, he was convicted. This man was convicted of shooting Rebecca Bletch several times in the head alongside Automobile Road in rural Muskegon County, Michigan on June 29th, 2014. At the time, she was jogging. Prosecutors say that the motive was to kidnap, sexually assault, and kill Bletch, as they say that he did to another woman, Jessica Haringa. And Willis is also charged in the kidnapping and murder of this young woman. And she disappeared from her gas station job in April of 2013. Her body has never been found. But that's not it. He's also been charged with the abduction attempt of a teenager who was taken, or was almost taken, along a rural Muskegon County road in April of 2016. She escaped him. She escaped him because she positively identified him as her potential abductor in the Rebecca Bletch case. This young woman testified. It was really, really compelling testimony. But now I want to understand the history of this guy. And Dr. Huber, I first want to just start with what we just saw. Whether it's him or whether it's any defendant, blowing a kiss at the gallery, what does that tell you?
Man, well, it's a lot of arrogance. This guy is obviously, based on not only that behavior, but murdering and killing these women like this, obviously a psychopath. And he would score really high in the psychopathy scale. One of the things that they get pleasure from is inflicting pain on people. I mean, go back to Jeffrey Dahmer when he talked about, strangling these 14-year-old girls. And when he would tell and describe for reporters this, when he would stand up, it was obvious he was sexually aroused by telling that story. They get reinforced from this. And man, you got a family up there, and they know you're the person who killed their child and they're this woman, and blowing a kiss like that, man, that is like pouring tons of salt in a wound. And I'm sure that was just a thrill for him.
He didn't like being called a coward when he was leaving the courtroom.
Exactly.
That's what did it. No, isn't that what did it? He didn't like them calling him a coward because he didn't want to sit there and hear the victim impact statements.
Yeah, and that's his narcissism. He wants to believe what he wants to believe, and he doesn't want to think that anybody suffered. Usually with a psychopath or a sociopath, they sit back and as long as things don't affect them, they don't care what happens to other human beings. Now, what's happening in this case is he typically doesn't care and doesn't have a physiological response to what's happening, but he knows those testimonies are going to affect his outcome and his sentencing. So he's dealing with a different set of mixed emotions than, say, you or I would.
So I need to understand this a little bit more for me and for our viewers as well. So he has been convicted in one of 3 major crimes involving young women. The prosecutors have identified that this guy has a pattern of sexually assaulting or kidnapping or raping and ultimately murdering women. And again, he will be facing 2 trials, one about the disappearance of Jessica Haringa and one about the potential abduction of this teenager. Mm-hmm. In your experience, people that have this pattern of being predators towards women, and we'll get into what his whole collection, what was in his house in a minute, and he had a ton of pornography and other things of that nature. But someone who finds the need to do this, what is it? Explain that to me.
Well, it's a power issue with them. Again, they're narcissistic. They believe that they are better than everybody else. And by forcing people, that reaffirms that. He's able to make individuals do things against their will. And even if that means he wants them to die right now, he kills them. And that, they don't have a choice in the matter. And that's where he's reinforced and rewarded. So, when we talk about sex crimes, they're typically, they're not about the sex, they're about the power that one individual can hold over another individual, and that's the turn on, or the hook for these psychopaths.
So it's not so much the acts, it's the power, the control. That's really where they get the kicks.
That's it right there. Yes, sir.
Okay. Wow. But he was married, believe it or not. This guy was married. How does someone get married and still have this dark life? I mean, I can't speak to their marriage. I can't spep to his wife. But, I mean, this guy entered into a union. This guy got married and still is doing this. I mean, I'm not sure I understand.
Successful psychopaths are able to function and cope in society. I mean, and what better cover, because who would we think? The loner, the lone guy who's out there who can't keep a job, which is typically what we would see, who can't be in relationships, that go out and kill these helpless women, or somehow helpless women. What better cover? Look at John Wayne Gacy. He worked as a clown, and he was married and had kids, and they didn't know who daddy was.
First of all, terrifying. Okay,
yes,
that's just a terrifying thought. Number one, him as a clown, so scary. That's my first issue there. But yeah, I mean, you see these people lead double lives. I mean, we covered a case just now out of Wisconsin, the Todd Kenhammer case, and I'm not sure you're familiar with it, but this guy lived a perfectly normal marriage to his wife of 25 years. Prosecutors say something happened, he snapped and killed his wife, and nobody saw it coming. And they made a point in the prosecution's case that, people can look like they have perfect lives on the outside. And you get surprised when they cheat, when they get divorced, when they get sick. So you really don't know what's going on in the psyche of a human being. Am I right?
That's exactly right. We can't read their minds. I mean, if we did, man, that would be great, wouldn't it? We'd be able to.
No, I think it would be the end of the world if we could read people's minds. I think it would be the end of the world as we know it.
Well, and the problem with that, and the thing we're glad we can't do that, is at all times it's normal for us to get upset at somebody and say something absurd that we would never do to ourselves in our brain. Like somebody cuts you off on a rainy day going down the highway, and you have to lock up your brakes, and man, you just want to pull them out of their car and punch them in the face. You say something like that, in real life, openly, people think, oh my God, this guy has all these violent tendencies. But you say that in one moment, and the next moment you go back to driving and you get on with your life.
Right.
It's the people who can't let go of that we're worried about.
Yeah, and rightfully so. You got to explain this one to me too. He had, Mr. Willis had a computer, and he had thousands of abduction, rape, torture, and kill videos. He had homemade videos of unknowing women in parking lots and girls at bus stops. He had one video entitled The Jogger, which we assume was Rebecca Blech. I don't understand what these videos, again, do. I mean, we talked earlier about exhibiting your control and dominance over somebody, but now watching these videos, what does that mean?
Well, okay, if you truly have true, voyeuristic, where the people you're photographing don't know you're watching them, that again is a power kind of thing. You're watching these people, and you know exactly what they're doing, you know where they're at, you know what kind of clothes they're wearing, all this type of stuff. It's almost like you have this godlike power to monitor and watch over these people. And that reinforces the narcissistic side of that psychopath and makes them feel even more empowered to move forward with their actions. It's pretty scary. Now, unfortunately, there's a difference between the psychopath who does this kind of stuff and somebody who has willing partners who know they're being videotaped, and it's kind of, role playing and stuff like that. And I've been asked to try to identify, is this role play, or is this the way this person is? And part of what you have to find out is, these people that are being videotaped and recorded, do they know what's going on? Mm-hmm. And that's kind of a key tenet. So when you go to some of these online sites where people watch these kinds of things, they have different names that allude to the fact that you're you're being a voyeur, but the girls and the guys in the videos are being paid for acting in that situation. It's not true voyeurism. It just gives the people that feeling that they're in that situation, and that the viewers are actually voyeurs. They get that feeling, but it's not true voyeurism by definition. The definition is the people in the cameras don't know they're being videotaped at all.
Wow. I mean, and that's not it. He also had a hard drive that had a folder labeled VIX, which would be short for victims,
Yes.
a subfolder labeled with the initials of Rebecca Blech and Jessica Harenga, as well as the code for the dates of their deaths. Now, is this a guy who just likes to be organized? I mean, why would somebody have this this folder here? I mean, what is that saying? Is it a sense of pride?
Well, I think it is a sense of pride. A lot of times, these relatively successful psychopaths who go in and they have these sprees and they're successful for a while, and they haven't been caught. They have this belief that they're smarter than all the police and the FBI and see everybody, all the investigative systems out there. So they keep this stuff organized. So in the event that they pass and nobody ever catches them, well, they go through and somebody can sit down at their laptop and go, oh my God, this guy was the one who did all these killings. And he's got it all nice and presented there basically for the media and things like that for his future, it's kind of his legacy.
Well, I mean, there's so much I could dissect with this guy, but I have to ask you I have to ask you this question because he did something that I keep seeing over and over with people that are involved in sexual crimes. He took he took the underwear of a coworker, Michelle Shontala, brought it home, kept it. What does that mean? I mean,
it's a trophy.
That's a trophy?
Yeah, it's a trophy. He's
even though he didn't do anything to this woman, he just collected something from her.
Well, he victimized her.
Yeah, well, that is true. That is true.
And he had power over her, and he was able to do this, and that's his trophy. He's got a tangible asset from his stalking and predatory behaviors, and that's a trophy.
So he is all about the control and the power and the trophy and the pride. So when he's sent to prison, and what happens then in terms of a psychological, is there a psychological shift in terms of people who are found guilty? Do they actually, people like in this Mr. Willis's case, do they change at all? Is there some sort of redemptive quality? Does he experience fear? Does he understand what he did? Is it really work for him, or is this guy just, we send him away just because he's an absolute menace to society? But does it change him at all, prison?
I've never seen the change. I mean, I follow people through their trials and then gone and talked with them in prison afterwards, and I haven't seen the change. That's part of the problem with individuals like this. They say, oh, well, let's rehabilitate them. They don't see a need for rehabilitation. They like the way they are, and they think it's successful for them. So they don't have a problem. It's not like someone who's depressed who, they know if they could get out of bed, they can actually hold a job, so help me learn to not be depressed. This is a very self-infatuation, narcissist. I am what everybody else should try to be like, and I'm the way the world is supposed to be run. And they convince themselves of this, and they walk into a prison and they have this attitude, and they'll take beatings, they'll be abused by other inmates, and they still have this mentality that they are right and that that everything they did was justified.
Well, good luck to him. I don't think that might work out so well. And finally, the question that I have, we saw yesterday the victim family members really speak about losing Rebecca Blech. For them, how does this healing process work? They saw the man who did this found guilty. He's in prison. How does their lives move forward from the results in the courtroom?
Well, and it's very problematic for them. They lost her, and now they've had to basically hold on to all their grieving process until this trial is over, and now they can actually begin to start the grieving. And they're going to go through all the different stages, and they do it at their own pace and within the family. Some people might get stuck at different areas like the anger and rage and And eventually they'll get to the acceptance. It doesn't mean that they accept it and say that it's right, but they understand the finality of it and that they need to get on with their lives. They're going to miss her forever, and she'll always be part of their thoughts and everything else. But they finally, after the months and months and months of going through this court, they're finally at a point where they can actually start grieving now.
Really, really sad. We're here with Dr. John Huber, forensic clinical psychologist, talking about the different defendants that we're covering in their cases today. Yesterday, but now we are going to wait for the Larry Whaley case to begin. Again, this is the case of out of Iowa. Larry Whaley, 60 years old, has been charged with second-degree murder in the death of 19-year-old Samantha Teeter by shooting her through the door of his apartment. What makes this case really unique is the fact that he has consistently and constantly communicated with the judge in this case, Judge Christopher C. Foy, writing him handwritten letters claiming he wouldn't receive a fair trial, that evidence is being withheld, his attorneys are lying to him, there's witness tampering, his cell phone and car have been stolen, his rights have been violated, all a plethora of stuff. It became to the point where the question became, is this guy even competent to stand trial? And as Dr. John Huber explained, he is competent in the sense that he understands the charges against him, he understands what's happening in the courtroom, he understands the whole process, and now it seems that he's claiming self-defense, that this killing was not intentional. In fact, after the shooting, it could be heard by police officers, him whispering to himself, they were trying to break in, We expect opening statements probably in about a half hour or so. As soon as we have a live courtroom feed, we'll make sure to go to it. In the meantime, I want to play you a hearing of Mr. Whaley in relation to this case. We're going to play it for you now. This is his first appearance in court, so let's play that now.
Right about here. Yeah, right in the middle so he can see you.
Yeah, there we go. Okay. Are you Larry Whaley?
I am.
Okay. Just so you know, Mr. Whaley, my name is Ron Wagon. Straight here. This is an initial appearance on the new charge that you've been charged with. These are public proceedings, so you can't see it. The media is present on my end over here, just so you know. I try to like to make people aware of that fact. I have an address for you of 116 17th Street Southeast, Apartment 2 in Mason City. Is that your address?
Yes.
Okay.
Yes.
You were originally charged with attempted murder, I believe. That has now been changed, and a new charge has been filed against you. The charge is murder in the first degree under 707.2 parentheses 1A, which provides a person commits murder in the first degree when a person commits murder under any of the following circumstances. Sub A is the person willfully, deliberately, and with premeditation kills another person. It is alleged that you used a firearm to kill the victim in this case with the initials ST. Do you understand that new charge that you've been charged with?
No, sir.
Okay. I will tell you again what it is. It is that you are charged with having used a firearm to kill the victim in this case. And as I said, first-degree murder is where a person commits murder in the first degree when the person commits murder under any of the following circumstances. Person willfully, deliberately, and with premeditation kills another person. In this case, that was ST. Okay? So that is the new charge that you are charged with. This is a Class A felony. It is punishable by up to life in prison without the possibility of parole. Do you understand that?
No, sir.
That means that if you are convicted of this charge, you would be spend your life in prison and you would not be eligible for parole, is what this means. Okay? You have various rights. One is the right to remain silent, not make any admissions or statements about the underlying facts of the case. If you do make any statements or admissions, they can be used against you. So I want you to not make any statements at this time. I want you to remain quiet other than to answer the questions that I ask as to whether or not you understand these. You also have the right to be represented by an attorney and to have an attorney appointed if you cannot afford one. The Public Defender's Office was appointed to represent you in the other case, but because this is a new filing, we need to have you file a new application for counsel in this case. Do you understand that right?
Yes.
Okay. So make sure you file that new application. They will give that to you, and then we will appoint the Public Defender again in this case, just like they were appointed in the other case. Just a minute here. I am scheduling your preliminary hearing in this case. Scheduling your preliminary hearing for December 15 at 8:30. That is not trial, that's a preliminary hearing to see if there's enough evidence to proceed with the charge. The county attorney can either put on evidence at the preliminary hearing, or they can file a document called a trial information ahead of that time that sets forth the facts that they are relying on. In most cases, that's what the county attorney will do, is file the trial information. If they do that, then the preliminary hearing will be canceled. So check with your attorney with regard to that. Keep in contact with your attorney to determine whether or not the preliminary hearing will go ahead. After that will be an arraignment date where you'll enter your plea of guilty or not guilty to the district court, and then it'll go on to trial or sentencing, depending on how you plead. Along the way, there will be various court proceedings. Make sure that you show up at all court proceedings along the way in this case. Right now, I am going to hold you on bond. Your bond will be increased under the new charge. It will now be $500,000 cash-only bond, okay? You can ask the district court to reduce the bond amount, but that is the bond amount that I am starting out and setting at this time. Do you have any questions about the bond amount or the preliminary hearing?
No, sir.
Okay. Then do you understand what I have told you with regard to this matter?
Not really, because it wasn't intentional, sir.
Okay. Don't, as I said, don't make any statements about your case. Okay. I'm just saying, do you have any questions with regard to the charge or
I was just wondering why it was first read.
No, okay. As I said, don't make any statements with regard to that. Okay. I am. Do you have? At this point, then, just get that form filled out. Make sure I can tell from that what your income is. Okay, and get that form filed with the court. Okay. Okay. Thank you.
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. We're showing you replays from yesterday, or excuse me, from Larry Whaley's first appearance in court. We expect the live coverage in his case to begin today with opening statements. I'm joined today by clinical forensic psychologist Dr. John Huber. Dr. Huber, you saw that. You saw the video. He basically was being read what his rights are in the trial, what's happening in the trial, what will happen in his case, and he started to speak out to the judge about, you know, what's happening. He says, and the judge had to stop him and said, you can't make any statements about that yet. Again, we're talking about his competency to stand trial, but how much is that competent to stand trial, and how much is that I just don't know courtroom procedure. I don't know how that works.
Well, that's part of competency, is knowing courtroom procedure, and the fact that, you know, if he continues to do it and it's disruptive, the judge can, you know, turn around and say, wait, this guy really isn't competent. They don't usually go that way. They usually warn them and tell them, you know, if this happens, that, again, they're going to remove him from the courtroom and they will proceed. You know, and then it begs the question, is that now grounds for, is that, and proof that he's not truly competent today? And that's the crazy thing about competency. It can change from day to day, especially when you have somebody who's mentally volatile like this, psychologically volatile. Not that he's aggressive or you know, going to hit his attorney or anything like that, but just because he fluctuates so much in his level of reality testing.
We talked a little bit off camera because Mr. Whaley, he wrote several letters to the judge in this case. That's what makes this case super unique, is that in claiming a number of things, that he wouldn't receive a fair trial, that the evidence is being withheld, his attorneys are lying to him, there's been witness tampering, his cell phone, his car, they've been stolen, his rights have been violated. Dr. Huber, you were talking a little bit about your experience with clients that actually communicate with the courtroom in this fashion.
Yes, and I've had clients who do that. In each case that I've had clients who did all this extracurricular contact with the judge and everything else, they were, in my opinion, and after the evaluation, not competent to stand trial. The clients then argued that they were competent and continued writing letters to the judge, and eventually decided the judge wasn't doing what he wanted, so actually went to federal system and the appeals process before he even found, his case was tried, and had judges actually schedule hearings until we got a hold of him and said, look, here's his evaluation. And competency doesn't have to do with intelligence. This guy actually wrote really nice, technically appropriate letters to these judges. That's why they listened to them and scheduled these hearings.
I was going to ask you about that, the actual language that he used in his letters, what you might have gleaned from it.
He actually did use legalese. I mean, he went through the library and wrote really good letters that, the attorneys, we sat down and kind of went through it, and he didn't use anything inappropriately. All the terminology he used was very appropriate, if it were fact. But what was going on was part of his delusions and his paranoia that was going on, that was keeping him from being able to identify reality from his hallucinations and fantasy.
Right. It's an interesting case to follow. As soon as we have a live feed, we'll make sure to go to it. Dr. John Huber and I are talking about both Larry Whaley and Jeffrey Willis, because there was a hearing yesterday regarding this man. Again, he was convicted of first-degree murder in the killing of Rebecca Bletch, faces life in prison without the possibility of parole. And he will be on trial for the for the disappearance of and kidnapping and disappearance of Jessica Haringa, as well as the potential abduction of a teenager. And there was yesterday a hearing regarding scheduling and victim impact statements. So I want to play for you right now, in case you missed it, the hearing yesterday from the Jeffrey Willis case.
All right. 14th Circuit Court of the County of Stevens State, Michigan is now in session. Judge William C. Mary presiding. Please be seated.
This is People versus Willis, file number 1600 3145, 3 counts, and we're here for sentence. Johnson, have you had a chance to review?
Yes, Your Honor. Your Honor. Well, I guess we're here for a couple things, Judge. We're here for the motion and the sentence.
Oh, correct. You're right. You're right.
However, and I've just been informed there's a third matter that I have to bring to the court's attention. Your Honor, it is the position of the defense that we are hereby requesting that my client be allowed to leave these proceedings at this juncture. He has informed me that that is his desire, and I would offer the court the opportunity to inquire of him if that's what he wishes to do. I don't know of any requirement that he actually be here. We would be obviously stipulating to proceed with sentencing and the motion thereafter. However, at this juncture, I'd ask the court to allow my client to be relieved of being present at this particular hearing.
Well, Judge, I mean, obviously, I guess I don't know of any. This is unprecedented for me. I've never had this motion ever been made before.
Well, not required to be.
And I don't disagree with that. It's unfortunate that he's choosing this cowardly way of doing it. That certainly he's been convicted. The family deserves the right to address the court, which they intend to do. And they also, in some respects, deserve the right to address the person convicted of killing their daughter and sister. But that being said, whatever the court decides, the court decides. But certainly, I think it's kind of, well, I'll leave it at that, Judge.
Your Honor, I don't think that's necessary. It's certainly up to the court whether you want to inquire.
Oh, I'm going to have to hear this from him. I'm not
All right.
going to have any error in the record here. They'll find me later that he wasn't here for a sentence.
Okay.
So, you want to interrogate him on that?
Shall we place him under oath, Judge?
No.
All right. Mr. Willis, you recognize that you have a right to attend all the hearings in this particular matter. Is that correct?
That's correct.
Do you know what we're doing here this morning?
I do.
What is that?
I'm here for sentencing.
Are you also whether we're having a motion on whether or not you remain in the county during the pendency of this next matter?
Yes.
And is it your desire to remain in the courtroom, or do you desire to be relieved at this time?
I desire to be relieved.
You don't have to be there.
correct, Your Honor, and he has signed his rights of notice of appeal and other documents. I'll provide those to the court at the end of the case. Thank you, Judge.
I'm advising you now, you have a right to appeal your conviction and sentence. If you're financially unable to retain an attorney, you may request to come in the county form to be provided within 4 days. Okay. I will ask you again, Mr. Johnson, if you have a chance to review
We're going to talk about the motion for consent.
Howard.
Bring him back.
Oh, he threw you a kiss. Oh, you want a kiss.
Hey, hold it. We got to quiet down. This is a court meeting. You have to follow the rules. I have to follow them. Everybody else does. Okay? This is a public assembly. Mr. Johnson?
Yes, Your Honor. As to the matter of the motion to retain Mr. Willis here in county during the pendency of the next matter, I'd ask the court to authorize the same. We've had a chance to discuss the matter with the sheriff and chambers, and I recognize his concerns. However, Your Honor, what we're simply asking is to retain the status quo, to continue to do what we've been doing for 18 months. We're not asking for any changes of status or situation. We're simply asking that he remain in the status that he's in. And if the county were able to accommodate that yesterday and the month before that and the 18 months before that, we're at a loss to see why at this juncture that has to change. I understand the status changes, but we ask that it remain the same. And while we've been informed that if Mr. Willis were to be taken out of county, he'd be moved back to Muskegon after he goes through his quarantine period. I will point out that the quarantine period, as I'm aware of it, lasts for about a month. We have about 2 months to trial, which means half the time that he would, between now and trial, he'd be unavailable to us. Yes, we will probably be able to write letters. We might even be able to go down to Jackson to see him. I'm not sure if that's the situation during quarantine. But again, it creates a situation where communication is broken. Mr. Willis, as I point out in my motion, has been the sole member of this party who's been with this case for 18 months. He's worked on it all day, all night for 18 months. He is an essential part of this defense team, and we need him now in order to prepare for the next trial. When we agreed to go to trial on the 3rd or the 6th of March, whatever it might be, it was under the expectation that he would be available. If he's not available for a month, then that throws a monkey wrench in, and we may have to come back to court to ask for a new situation. I would simply point out that under normal circumstances, Judge, you go to see your client maybe 5-6 times, and you're ready for trial, that sort of thing. Mr. Willis is seen by our intern once a week. He is seen by an attorney at least once a week, maybe 2 attorneys a week. It's been very intense, and it's been very intense for a very long time. He provides copious notes. We give notes back to him. We've had an interview from the jail. The sheriff is too kind. It is much more difficult to do things in the prison than it is in the jail. We've had an interview with his DNA expert from his jail cell through a cell phone. That's not available to us in prison. The bringing in the laptops to watch videos and listen to CDs is not available to us in prison. He's not without going through the warden. The other exchanges that we've had, that we're going to have, that we've been having, we can't simply. It's just it increases the difficulty of defense by an exponential amount. It makes it difficult for us to do our job. It makes it difficult to provide him with a defense when the next trial comes. And again, we're asking to maintain the status quo. And I think it's a reasonable request under the circumstances. We ask the court to accommodate us in this request. Thank you, John.
You want to have on that?
Well, just a couple of things, Judge. There is a difference in a couple of respects. One, when the court passes sentence, the Michigan Department of Corrections takes over jurisdiction. I don't even know if the court has the ability to make this decision or not. Secondly, as the sheriff indicated when we talked in chambers, although his location remains constant, his status does not. He's no longer a Muskegon County prisoner awaiting trial, in a sense. He's now a convicted felon and is a Michigan Department of Corrections prisoner. And as I think the sheriff so aptly put to the court when we were in chambers, the rules on how he's dealt with, even inside the county jail, change. And the same limitations that Mr. Johnson's worried about, and I don't know whether or not that's true or not as far as the Department of Corrections is concerned, they're going to happen here in the jail. The other thing I would say, too, is there's a lot of modern technology. I mean, the court has the Polycom. I know there's a Polycom unit on the 6th floor in a private room. All prisons, I think, are equipped with Polycom units where you can have direct communication with an individual even though you're not in the same room. Quite frankly, Judge, we spent a long time getting up to the trial. We spent 3 weeks in trial. The jury convicted Mr. Willis. In some respects, I don't think he gets the benefit of staying here. He needs to go where essentially he's supposed to go, which is the Department of Corrections. There is no, I know some defense brief, there is no case law that, essentially supports their position. I think they're basing it on maybe equity, but certainly the equities also weigh in the favor of sentencing him and having him transported to the facility where every other prisoner goes when they're sentenced to the Department of Corrections.
Well, I've considered the motion, and I certainly want to give Mr. Willis every opportunity to have a vigorous, adequate defense in this case. He's entitled by the Constitution to have that, and I'm certain that he will be provided with that. I do not feel that his location is something that I have any authority over once he's been sentenced. I don't have any authority to designate where a prisoner of the Department of Corrections is housed, and once he's been sentenced, the Department of Corrections makes that decision. I don't have any authority to interfere with that. So I don't believe I can grant the motion because I don't believe I have any authority to do that, number one. Number two, I have consulted with the sheriff about this matter in the presence of both counsel. And he's advised that this presents a security risk in his view, both to the defendant as well as to other inmates in the jail because of his status now as an MDOC prisoner and the restrictions on his ability to impose sanctions for any behavior that Mr. Willis might engage in jail, even though he's a prisoner of the Department of Corrections. So for both reasons, number one, that I don't believe I have the authority to make that decision, and number two, because of the security concerns expressed by the sheriff, I'm denying the motion. Now let's move forward to the sentencing. Mr. Johnson, have you had a chance to review the report?
Yes, Your Honor, I have had the chance to review my report.
Have you reviewed it with your client?
I did.
Okay. Do you have any additions or corrections?
Your Honor, there is a technical correction to be made. I believe if I can. This page is here. Okay. There are on Judge on the pages, the third set of page 1 and 2, the Michigan Basic Information Report. It indicates, I think, at least 3 places that the adjudication here was by plea, and obviously that was not the case.
Okay, correct. Adjudication was by trial by jury. So please make somebody here can do this.
Yep,
Yes,
right behind you.
Okay, please make that correction.
I don't have any additional corrections or additions to make to
All right, anything you want to say by way of allocution?
Your Honor, the jury has spoken on this matter. This matter is now goes to the Court of Appeals and et cetera, and they will have the final word. So I have nothing in addition to that.
All right, thank you. Mr. Hilson, have you had a chance to review the report?
I have, Your Honor.
Anything that you'd like to say, or do you have any victims who would like to speak?
I will save my comments to the end, but I would like to invite Rebecca Bletch's mother, her 2 sisters, and a friend who wish to address the court.
Okay.
Whoever wants to go first.
This is written under
If you could just tell us your name so that we have that for the record.
Nicole Whipper.
Okay, thank you. Go ahead.
These were written hoping that the coward that walked out was going to be here. I
first want to thank the members of the jury and the court and all involved in my sister's murder investigation. Secondly, I want to thank MJN for her bravery. If it were not for her, we would not be here today. I stand before you full of hurt and anger, neither of which seem to go away. I hurt because Jeffrey killed a mother. I hurt because he killed his wife. I hurt because he killed a daughter, a sister, and a friend. The moment he killed Becky, he killed a part of all who knew her. I'm angry at the fact that he tried to blame my brother-in-law, a good man who loved his wife. I'm angry that we now all have to pay for him to remain behind bars. I'm angry that nothing I say today will bring my sister back. What I wouldn't give to hear that laugh again. Today is not closure. As a matter of fact, no day will ever be considered closure. June 29, 2014, our family lost, and that pain will never go away. The court may find justice in the fact that he received a guilty verdict. I find no justice in the fact that he took my sister's life, and he remains to live. I want to leave here asking that he spare another family further heartache. I ask that he find it in himself to give the Herringa family their daughter back. They deserve a body to lay to rest. And he claims that he's not a monster, but his actions speak louder than words.
Okay, thank you, ma'am. And I also want the record to reflect that I do have a written copy of that that will be attached to the
I am Deborah Reamer, Rebecca's mother, and I will never...
Welcome back to the Law&Crime Network, everybody. This is Jesse Weber. We're showing you clips yesterday from the sentencing hearing in the Jeffrey Willis case, and he was sentenced to life in prison for the first-degree murder of Rebecca Bletch. I'm joined today by a very special guest. I'm so happy he's here, forensic clinical psychologist Dr. John Huber, to talk a little bit about the psychology of Mr. Willis, as well as Larry Whaley, which is another case we're covering today. Now, Doctor, the question that I have, we talked a little bit about it. This guy, all right, was convicted of a horrible crime. He's going to be facing trial for two separate incidents, one about the disappearance of a young woman named Jessica Herringa, as well as the potential abduction of a teenager. And you just heard Rebecca Bletch's family members talking about that teenager who testified, this young girl who was almost abducted. Do you think people who were around Mr. Willis, worked with him, knew him, they might not have had any idea about this life that he had? Am I right?
I bet they had no idea, absolutely. And they probably thought he was a nice guy, and he was competent at work, and he seemed to make everybody feel comfortable and at home whenever he's around. That's probably what we're going to hear from 99% of the people around him.
That is so terrifying. It's really, really terrifying. And as I said, there's three separate crimes here. One is obviously a murder. One is a disappearance and probably a murder as well. And one was a potential abduction. Is there anything that you can glean from these three cases, these three incidents, that are maybe a little similar to show a pattern, or is there anything that's different about them that might show his motives were different for each individual? Again, he hasn't faced trial for those other two, Jessica Herringa and this teenager. But if we just assume for the fact that he was guilty of all three crimes, is there anything that tells you something about maybe each one was different for a specific reason, maybe had different plans for each three, or it really is the same kind of pattern?
It's the same kind of pattern, and what he's looking for is opportunity. And if he can, you talked about, the computer he had and the database he had with all this information. I mean, he's scouting and acting on that. And actually, I'm kind of surprised it's only three people. There's before he became as organized, there may be some other victims prior to his organization, before he starts putting these things together like that.
And as you said, victims, I mean, there's these kinds of victims, and then, as you said earlier, there's victims he stole his co-workers' underwear. That's a victim. There's people he probably, spied on. That's victims. So, and whatever else in that kind of realm, they're victims. What's interesting about this case is he took the stand in his own defense, said he had nothing to do with it. That seems like the same pattern of arrogance that we saw in the beginning of this tape when he blew a kiss to the jury. It's not to the jury, to the victims of this, the victim family members. Is that the same kind of thing here?
Oh, exactly. And in his mind, he is smarter and better than everybody else, and it's just a fluke that he got caught and he's in court.
So there was one thing when he testified. The prosecutor asked why he would have these videos, these mutilation videos, these abduction videos, these really disturbing videos. He explained that his wife at the time had an abortion, that their sex life had stopped, and that their brutal videos were his outlet. Is there such a truth in that, you think?
Wow. You know, I'd have to sit down with him and actually do some testing and to see if there's any kind of truth to that. I think the actual things happen, you know, the losing the child and that kind of stuff probably did actually happen, but whether or not that's a stimulus for him to do these things, I think he's just making excuses.
Yeah, I agree with you. It's hard to know exactly what spurred it, if anything, and I think it's a really interesting discussion about his wife and what it was like to be married to this guy. I mean, to be in marriages where you don't really know, or maybe, again, I can't speak about it, but we talked a little bit earlier about when people are so intimate, boyfriend,
right,
girlfriend, married, and you don't really know the other side of them. How do people keep something a secret like that from somebody they're so intimate with?
Well, I think the fact that, you know, he said they lost the child and then there was no sex, she probably felt like there wasn't a connection and she wasn't feeling safe to go back and to have sex with this man. So there was part of her that was saying their connection isn't complete. There's something missing in this relationship. That's my gut feeling. Again, I haven't evaluated any of these people to be able to say definitely.
Right. So we're covering the Jeffrey Willis case as well as the Larry Whaley case, which we do expect live testimony from today, opening statements. This is a case out of Iowa. Larry Whaley is 60 years old. He's been charged with second-degree murder in the death of 19-year-old Samantha Teeter by shooting her through the door of his apartment. Whaley has actually written letters to the judge in this case, Judge Christopher C. Foy, claiming he wouldn't receive a fair trial. Evidence is being withheld. His attorneys are lying to him. There's been witness tampering. His cell phone and car have been stolen, and his rights have been violated. He has, despite all of this, been deemed competent to stand trial, and we do expect opening arguments. Dr. John Huber has been talking about the Whaley case, what we can expect from this man, what it means to be deemed competent. I do have one more question for you, Dr. Huber. I know we have to let you go soon. The idea of resorting to violence, if somebody thought somebody might have been breaking in, or we'll have to find more details of it, but resorting to having a gun and firing it, what does that tell you about the psyche of a person who can do that?
Well, you know, many states, Texas included, have a right to defend yourself if you feel your life is threatened. And that's the key terminology. I feel my life is threatened. And a lot of people have been approached by people that weren't really threatening them, but because of what led up to that connection and behaviors and things that had happened, they were able to justify that, you know, after A, B, and C happened, this person approached me, and now I feel like, you know, he was a continuation of those other events. And in fact, it turned out they weren't, but I felt a threat to my life, so I took lethal force. And people have been acquitted of murdering people in those situations as a self-defense plea, at least here in Texas, that I've you know, had the opportunity to witness. And, you know, it's that feeling, that perception that my life is at risk. And in his case, it sounds like there were some other things that were altering that perception. It may have been drugs, may have been a mental health issue, but we don't know at this point exactly what that. I mean, I'd like to see what his blood alcohol and any kind of tox screens that they did after they arrested him were like. I'd really like to see that.
I would like to see, and usually we see in self-defense cases, defendants taking the stand. I mean, that I imagine for you, if you see someone take the stand, a defendant take the stand, that's just a great day for you to watch their mannerisms, how they speak, what they're talking about, their rationale. I think that you would have, if that actually happens, we would love to have you back to talk about it.
Excellent.
Right?
Excellent. Yeah, and I'd like to watch that too, because, you know, I think he's having some paranoia issues, and I think there may be some underlying mental health issues, especially with reality testing and thought processing. And I'd like to see how he's able to get through that, because, he may express all these things, but what it boils down to is his attorney and with his story going to be able to get him to share and get the jury to feel like he reasonably felt threatened, if that's going to be his actual defense going forward.
Forensic clinical psychologist Dr. John Huber, thank you so much for talking with us today about both of these cases. Really, really important. Really, really hard to listen to half these descriptions of these cases, particularly Jeffrey Willis, who has quite the colorful history, really disturbing things in his life. But you really did provide a great context for us to understand. So thank you again.
Thank you, Jesse.